In Section 234 of the Criminal Code of Canada, manslaughter is defined as culpable homicide that is not murder or infanticide. In other words, manslaughter is when someone causes another person's death through an unlawful act, but without the intention to kill. It's often used when the accused's actions were reckless or negligent but not deliberate. But the question we'll be exploring today is if Canada should remove manslaughter from the criminal code altogether. To simplify manslaughter, it exists as a middle ground between murder and accidental death. It applies when a person didn't mean to kill, but still caused someone's death due to their unlawful or dangerous actions. However, this middle ground creates a gray area. Sometimes offenders walk away with a lighter sentence even though the harm they caused was extreme. Critics argue that manslaughter waters down accountability in serious cases, but supporters say it's a necessary legal tool to reflect differences in intent and circumstance. So, what happens when the charge is misused, or when it leaves the public feeling like justice hasn't been served? To understand this better, let's look at two major Canadian court cases, R.V. Callan and R.V. Creighton. In 2013, Nicholas Callan was living with his girlfriend, Loretta Saunders, in Nova Scotia. Saunders, a 26-year-old Inuk woman and university student, had been subletting her apartment to Callan. A dispute broke out after she discovered that Callan had stolen and pawned some of her belongings. At some point after the argument, Saunders was killed. Callan admitted to disposing her body by putting it in a hockey bag and abandoning it off a highway, then later returning to burn it in a fire pit. However, he claimed he didn't kill her intentionally, and no body was found to determine the exact cause of death. Callan was initially charged with second-degree murder, but he was convicted of manslaughter. The jury believed he was responsible for Saunders' death, but they weren't convinced beyond a reasonable doubt that he had meant to kill her. The problem? The disposal of the body, what Callan admitted to, was so extreme, so intentional, and so disrespectful that many felt the murder conviction was more appropriate. This case raised a serious question. Should someone who burns a human body to destroy evidence be able to claim that death was just a tragic accident? Ian Creighton was a drug dealer who injected a woman named Debbie LeBlanc with cocaine during a party. LeBlanc had never used drugs before, resulting in her having a fatal reaction and then dying. Creighton didn't seek help. Instead, he left her unconscious on the floor and eventually fled. He was charged with unlawful act manslaughter, causing death by committing an illegal act, in this case, trafficking and injecting drugs. The legal question in this case was, should a person be guilty of manslaughter if they didn't foresee that death could be a result, but still acted unlawfully and recklessly? The court said yes. The majority ruled that unlawful act manslaughter does not require the accused to have foreseen death, just that the unlawful act was objectively dangerous. But that opens another ethical dilemma. Creighton's actions were undeniably reckless, but did he deserve the same stigma as people who violently kill? Or was the law too harsh, punishing someone for consequences he didn't specifically intend? So, in Callan's case, the law may have gone too easy, but in Creighton's case, some say it went too far. These are just two of many cases that show the deep flaws in how manslaughter is applied. So, why should we remove it? Number 1. Lack of consistency. The standard for what qualifies as manslaughter is blurry. In one case, someone who burned a body gets a lighter sentence. In another, a drug user is hit with a heavy conviction. The law is applied unevenly. Number 2. Escape hatch for murderers. In high-profile cases like Callan's, manslaughter becomes an easy out for the accused. Even with extreme actions, like hiding or burning a body, juries can settle for a lower charge if they aren't 100% sure of intent. Number 3. Undermines public trust. Victims' families often feel betrayed by manslaughter verdicts. They see them as justice denied. If someone kills, the public expects a murder conviction, but manslaughter allows offenders to avoid the full weight of the justice system. Number 4. Better alternatives exist. Instead of keeping manslaughter, the law can rely on degrees of murder, like first or second degree, or create a clear category that reflects the role of recklessness, not just intent. Number 5. Moral responsibility is lost. By focusing only on whether someone meant to kill, manslaughter downplays how reckless or dangerous the person's actions were. Someone died. Shouldn't that matter more than what was in their head? Manslaughter was created to show mercy when there was no intent to kill, but in many modern-day cases, it does the opposite of it. Instead, it creates loopholes and inconsistency. Victims are denied justice, offenders sometimes walk away free with short sentences, and the public is left wondering whether the legal system truly values human life. The law should be clear, consistent, and fair. So to answer the question, should Canada remove manslaughter from the criminal code? Many would say yes, not because the accused don't deserve fair trials, but because the current system is too vague. Too often is it exploited, and too often is it unfair to the victims.
Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school to learn the golden rule. When you acted like a bloody fool, if you get hot then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you?